Good morning, Your Honor. Andrew Flores on behalf of Ms. Sherlock, who is present via Teams.
All right, welcome to Ms. Sherlock.
Morning, Your Honor. Doug Pettit on behalf of Ada Austin and the Austin Law Group.
Mr. Pettit, welcome.
Good morning, Your Honor. Andrew Hall on behalf of defendant Stephen Lake.
Hello. Anyone else? Okay, with regard to the motion to vacate judgments, Mr. Flores, you wanted to be heard?
Yes, briefly, Your Honor. So,
okay.
Again, Your Honor, we're here again about the straw man practice that we described in the complaint. The court, I've read the court's tentative. In essence, it says that the Court of Appeals has already ruled on this and has become the law of the case. However, in my reading of the opinion from the Court of Appeals, in essence, they say that we didn't provide any evidence, and had we provided evidence, they would likely agree with us. So at this point, what we've done, Your Honor, in our motion is provided that evidence, that newly discovered evidence of illegality. First and foremost, there is the affidavit of Mr. Zamora, which discusses his presence at meetings in which Ms. Austin discussed with her clients a monopoly over the marijuana industry. And also, there's independent evaluation of Mr. Sherlock's death, which this forensic evaluation came to the conclusion that his death was not consistent with suicide. So we have those things. But even more importantly than that, Your Honor, we've already argued before regarding the straw man practice, is that it is facially criminally illegal. In essence, Your Honor, if I had an individual come to my office who has been convicted of drug dealing or was cited for drug dealing and wants me to get them a cannabis license, that is an illegal purpose. That is not something that you can engage in without, especially the way they did it, Your Honor. What they've done is they've petitioned for permits to operate a marijuana dispensary secretly in the name of another agent without disclosing, even though the disclosure laws and the policy justification for the legal marijuana industry specifically states that transparency is the biggest thing. So in essence, with respect to the doctrine of the law of the case, Your Honor, that doctrine is discretionary. It's a discretionary policy which shouldn't be followed if it results in a manifestly unjust decision. And that is the Amato versus Mercury casualty case. And I think that this is void in excess of jurisdiction because it condones, ratifies, and validates what amounts to illegal contracts. So by providing this evidence to the court, in essence, the court now has a sua sponte duty to ensure that it's not ratifying illegal activity. And again, under the civil code, contracts must have a lawful object. These are not lawful objects. They're in essence secret agreements to obtain dispensaries for individuals who have been previously cited for operating illegal dispensaries. So again, and I want to reiterate, Your Honor, the defendants have never contradicted or in any way disputed these particular facts, that they were hired by these individuals, that they applied for CUP permits on behalf of those individuals without disclosing their interests in the name of their agents. So again, I believe that the court has the duty to make sure it's not ratifying illegal activity. I believe that the doctrine of the case does not apply because it is wholly manifesting an unjust decision, right? It's supporting an unjust decision. And even to go as far as say that even if the appellate court has made this decision, it does not preclude them from reconsidering the question decided on their former appeal. So the court has the ability to consider this new evidence because it wasn't available at the time of the previous appeal, and we'd ask that the court do that and review this to ensure that it's not ratifying illegal conduct.
All right, thank you. Mr. Pettit.
Courts accurately, I think, looked at this issue and it's done in a ruling. Anti-stop's been granted, Court of Appeals affirmed. It's law of the case. There's nothing left to be argued. All of this was argued previously and it's been rejected both by you and by the Court of Appeal. There's no basis to vacate the judgment.
Mr. Hall?
We have no interest in this motion, Your Honor.
All right, very well. Thank you very much. I appreciate the argument, Mr. Flores, but the tentative will be confirmed. Thank you. Oh,